Okay. So. All rise. The United States Bankruptcy Court is now in session. Be seated, please. Ken Smith, Theodore Visner, case number 10-23064.
Good morning. Are you Mr. Visner?
Yes, sir, I am.
Good morning to you. Thank you for being here today, sir. There are a number of things that I wanted to address today. The first is that there was an order previously entered by this court. The court reopened the matter, and then we requested that you serve certain documents on parties. It didn't appear that occurred, so I asked you to be here, and you weren't here. And then I see you filed another pleading with the court, asking the court to set that previous order aside and let the case continue open. You still want to go forward in this court to air your grievances regarding certain matters that you had in the original motion to reopen the case, sir?
Would you mind introducing yourself, Your Honor?
I've been introduced already, sir.
You're Daniel Opperman?
Right.
Last time I saw you was in 2010, and I guess I don't recognize you.
Oh, well, I'm sorry. I don't think I've changed that much, sir.
Well, I think it was pretty clear in the motion that, yes, this matter needs to move forward in the federal court.
And fair enough. Who are the parties that you want to basically assert your rights against, sir?
That wasn't clear in the motion, Your Honor?
No, it wasn't.
Shelly Sweet and Bruce Havens orchestrated this fraud on this federal court.
Okay.
Through this notice of intent to sell and take possession that was filed on Monday, September 20th, 2010, approximately 1/2 hour after Bruce Havens filed his notice of appearance. His notice of appearance differed from the notice of intent to sell and take possession. The notice of appearance was obviously filed first, and the notice of intent to sell and take possession was filed second. Bruce Havens stripped the signature block of the second filing so that it didn't say notice of intent to, or it didn't say attorney for Shelly Sweet. And it didn't say respectfully submitted. And that document was created to look like a federal court ordered eviction where my home and its contents were lost.
That federal house was located where, sir?
829 East Walton in Mount Pleasant, Michigan.
Fair enough. And that's the property that you're concerned about to bring to the court's attention. Is that correct, sir?
That is correct.
As well as the personal property that you had of that house?
That is correct.
And that would be in 2010?
That is correct.
Fair enough. And the parties that you seek some relief against would be Mr. Havens as well as his client. Is that correct, Mr. Visner?
That is correct.
Anybody else?
Are you willing to tell me right now whether or not this court was a willing participant in this fraud against the creditors?
Sir, I don't think we were. Let me just say it that way. I'm trying to figure out, I'm trying to narrow it down because you've obviously filed this pleading and you want this court to do something to grant relief in your favor and against somebody else. Fair?
Fair.
Okay. So I need to know, one, who do you want to have this court bring here to explain to me what happened? I'm going to hear from you, and I'm going to hear from them. That's how we typically do this. I just want to know.
Due process, right? I get it. Yeah.
I just want to know who should we have brought in here, because the pleading that you filed recently with the court with the pictures of all the envelopes that you had, I don't think hardly any of those people really are involved in that. And I just want to make sure that we can narrow it down to those parties that you believe you have claims against, bring those people in the court, and then hear what happened. That's all I really want to do.
Well, Your Honor, the claims are obviously not against the creditors in general.
Right.
Just the ones that perpetrated the fraud upon this court.
And I don't know who those are. So that's why I'm asking you, who do you want me to order relief against, sir?
Shelly Sweet.
Okay.
Bruce Havens.
Right.
The Isabella County Sheriff's Department.
Those three?
Essentially the co-conspirators.
So I've written down Shelly Sweet, Bruce Havens, and the Isabella County Sheriff
Department,
Okay.
which is a subcorp of the county, so Isabella County.
Should include them as well then?
Well, primarily. The Sheriff's Department is a department of the county, so yeah.
Right. Sir, because as I read your most recent pleading, and then I read your previous pleading when you asked to reopen the case, I've pieced together a little bit more in where I was not sure what you wanted, and now you told me more, and where I was not sure what needed to be done, and now I know better, is that the previous order of the court asked you to send the copy of the order reopening the case as well as the amended motion. And your certificate, as I read it, sir, which was, I think, our docket number 117, said that you sent the court's order reopening the case. And that's only like half of what I really wanted to have done. But I now understand that it's really not all your other creditors. It's essentially 4 entities. Ms. Sweet, Mr. Havens, the Isabella County Sheriff's Department, and Isabella County. Those are the 4 that you really have a complaint against, it sounds like to me. Is that a fair statement?
And we should put Robert Wheeler on that list. It was Shelly Sweet's boyfriend at the time.
I see.
There's relevant testimony from him.
Yeah, there's 2 different things there. First off, what's relevant testimony from a witness doesn't mean that you're a party to it. I'm trying to just make sure that...
Oh, he was a party to it. I have a picture of him in my house stealing my stuff on the day it was looted.
Robert Wheeler?
Yeah.
Okay. So those would be now the 5 entities or individuals that you have claims against, as you stated in your motion filed with the court late last year.
And so we're clear. Paul Chamberlain, the chief judge of Isabella County, needs to be on that list too. Paul Chamberlain heard a summary disposition in a civil action against the same parties. And the county's lawyer presented to the court that this court had abandoned our personal property, and that's why they were allowed to take it. The trustee in our bankruptcy abandoned its claim on our personal property, and that was used to win a summary judgment in the lower court.
Sir, just give me a second. I want to look for something real quick.
Okay.
Because you're going back to the October 2010 order, right?
The October 2010 order. Yeah.
Right. So give me a second.
I believe you signed it on the 8th, October 8th. The hearing was on October 6th.
Well, the order said that Ms. Sweet was authorized to sell the real property at 829 East Walton.
May I interrupt you for a moment?
Go ahead.
Is it possible for me to see a copy of that as you're reading it?
I tell you what, it is. We just need to warm up the system.
Oh, okay. That's cool.
Oops. I also need to turn something on. it does get better with time.
Okay.
So give it a minute to. Now I was looking at in October, I think it's 8. Number 35. I was looking at this order.
Okay.
A creditor, Shelly Sweet, is authorized to sell real property at 829 East Walton Road, Mount Pleasant, Michigan, 48858. Let's skip B because it's interesting, but it doesn't apply here, I don't think. C, the court reserves for further determination all issues surrounding personal property transfers from and after the filing of the bankruptcy petition and any related issues surrounding the conduct of the parties during that period. C, 2 C's for some reason. The court further determines that the property referred to in creditor's notice of intent to sell is specifically deemed not to have been abandoned by this order may be raised by either party at that later date. You're one of the other parties.
That is correct.
Okay. So that's what, this is the springboard for you wanting to come here and ask for relief against these 5 or 6 individuals.
The notice of intent to sell that was filed on Monday, September 20th, 2010, was the filing of an intent to commit a crime.
I'm sorry, give me the date again, please.
It was filed by Bruce Havens on Monday, September 20th, 2010. The notice of intent to sell and take possession was intended to be executed the following Saturday.
Okay.
Before the objection hearing.
Mm-hmm.
The debtor's objection hearing to that notice of intent to sell and take possession was converted by this court into a creditor's motion hearing on that very same notice after the action described in the notice of intent to sell and take possession had already occurred. So this objection hearing and this order to follow are a product of something that was already blown up. We were objecting to an erroneous bullshit filing by Bruce Havens, and that objection hearing was held on October 6th. But our home and our property had been sold the previous month in September, the weekend prior to September 27th, 2010.
Okay. Now I hear what you're saying.
So we came to this court objecting to this fraud on the court. At that time, I didn't know what fraud on the court was.
Mm-hmm.
But this criminal intent was filed in this notice of intent to sell and take possession on September 20th by Bruce Havens.
This one right here at 21?
I believe all my records and notes with regard to this case and several others were ruined when the Sheriff's Department recently trashed out my house. I'm not sure if you're aware of that.
No, but I'm more concerned about 829 East Walton because that's what you owned before you filed bankruptcy.
Yes.
See, sir, this court has certain jurisdiction, and that is regarding property that you owned back in approximately 2010 when the matter was, the petition was filed. So I'm most concerned about that.
As opposed to what?
Well, there's so many other things in the world to be concerned about in regard to your case. I'm concerned about the 2010 actions because you raised some issues about how not only this pleading was filed, but as I piece it together, how this order was entered. And then, most importantly, I suspect, the enforcement of that order, because I frankly read out the October 8, 2010 order to say that you, as well as I guess Ms. Sweet, either one of you can come to this court and have this court determine the personal property issues, at the very least.
And the real estate issues. Have you listened to the transcript, Your Honor?
No, I've not.
I've got it posted on YouTube. Bruce Havens commits fraud on the federal court. It's been up for almost 3 years now, I think.
Well, I don't look at a lot of YouTube.
Well, the transcripts from those proceedings were given to us when we were leaving. And it's the transcript, not YouTube, that I'm...
And that's what I would use as evidence versus a YouTube, just because we...
Correct. They're already on file here. I'm sure I only got a copy of the master file, and it will be the master file that's used as evidence and not any copies.
Mm-hmm. So what I want to know is, you want me to keep the case open?
The hearing on October 6th that produced this order on October 8th, you told us to be careful.
Mm-hmm.
You said that it would probably be best for us to allow A to happen. Now, keep in mind, this is October 6th. Okay, the order is dated October 8th. You made this order out later because I think Bruce Havens drafted it. That's probably why there's 2 C's. Okay, but from our objection hearing on October the 6th, everything had already happened. Our house was gone. Our property had been stolen.
Right.
And this was all facilitated by Clinton Steiner, Sheriff Deputy, Isabella County.
That's the Sheriff's Department that you want to include.
I was thrown in jail for calling the police to report our property being stolen. I was kidnapped.
When did that occur, sir?
On September 27th, 2010, before the October 6th objection hearing to the notice of intent to sell and take possession.
And you want to bring all this up to us in the form of a hearing in the near future?
I'm addressing this court. I'm talking about kidnapping. I'm talking about the theft of real and personal property.
Right.
And even though the FBI is sitting in this courtroom gallery, mm-hmm. no one is lifting a finger to help with these issues. And this federal court, although it issued an order after all of this happened, seems to be failing to recognize what actually did happen. To kick off the 6 years of hell for not only myself, but my family.
Well, sir, I want to hear about it. You know, what I want to do, though, is hear about it in the process that we follow here, and that is let you have the opportunity to bring everything into court and have the people or the entities that you feel...
This court needs to recognize the prima facie nature of my claim here. Bruce Havens filed an erroneous document that meant nothing to this court. It meant nothing to the debtors. It meant nothing to the creditors. Just a filing. That filing was printed and handed to a sheriff's department and executed as if it were a court-ordered eviction, as Bruce Havens as the judge. That's how that document was used, and that was its intended use.
What document was that? Number 35, or which is the order, or number
920, notice of intent to sell.
Number 21.
Yes.
You mind if I click on that?
Go ahead. No, go ahead.
I'm going to hit view all so that we can look at everything at the same time. So you're telling me that this notice of intent, which is I'm scrolling through it, signed by Mr. Havens.
Okay, stop there for a moment.
Sure. I'm going back.
Signed Bruce K. Havens. This was an electronic filing, I believe, through your right. Electronic filing.
Is such the bottom.
Okay. Bruce K. Havens, his P number. It doesn't say attorney for Shelly Sweet. And it doesn't say respectfully submitted. The top of this document does not say a motion. Bruce Havens is not asking this court to do anything. Bruce K. Havens is basically stating criminal intent. Now, if you go back to the document filed just previous to this, would be the Bruce Havens notice of appearance.
Right there, number 20.
Notice of appearance, yep.
Right.
If we go to the bottom, okay, right there. This is how this court is addressed by bar card carrying members of the Michigan Bar. Who's Bruce Havens? Here he spells it right out. So this signature block was created attorney for Shelly Sweet, respectfully submitted, there's no question at all in anybody's mind that Bruce Havens is not a federal court judge. This was filed first.
Right.
The document filed 30 minutes later was about 30 minutes later. The notice of intent to sell and take possession. The signature block was changed to make it look like a federal court order. And that's exactly how it was used.
I see. I did not know that. So, you're right. It's about a half hour later. I see the difference that you're talking about because I've scrolled down to page 2 of the first document at number 21. And it says Bruce K. Havens, and then his address.
This document was created, Your Honor, to circumvent the stay of federal court bankruptcy. We entered into bankruptcy to keep this crazy lady from taking our house. The automatic stay of bankruptcy was completely ignored in summary proceedings local in Isabella County. A judge by the name of Rush ignored the suggestion of bankruptcy and issued Shelly Sweet an order of possession. We were found in default because our lawyer went, our bankruptcy lawyer, Leslie Honig. I guess, I don't know, she didn't do the right thing. She didn't file a notice of appearance, but she was basically there on special appearance to inform that court that we were in bankruptcy and we were protected by the automatic bankruptcy stay. Now, those summary proceedings never yielded any fruit. No eviction order was ever issued or granted by that court.
Right.
In fact, on September 29th, 2010, those proceedings were administratively closed by Bruce Havens and Shelly Sweet because they had the solution here in the federal court to commit this fraud, to produce this document that looks like a court's order. It's not.
Wondered about, as I read your first pleading to reopen, you indicated that it was closed on September 29, but you're saying to me that this document being 21, dated September 20, somehow or another was used to replace what would have happened in the Isabella County District Court?
The summary proceedings against Kathy Smith and myself with regard to the property 829 East Walton in Mount Pleasant, Michigan, was being addressed in summary proceedings by Shelly Sweet and her lawyer, I believe it was Nancy Gallagher, in the Isabella County Court. Even though both Shelly Sweet and Nancy Gallagher were noticed of these proceedings here in this federal bankruptcy court. On August 10th, we filed this bankruptcy jointly, my wife and I. On August 18th, after Shelly Sweet and her lawyer were informed of our bankruptcy, they initiated summary proceedings in the lower court on August 18th, 8 days after we filed for bankruptcy, and were supposed to be protected by a federal court bankruptcy stay.
Right.
Now, those summary proceedings against Kathy Smith and myself, we had Judge Rush entered a default order possession against us because we didn't go to the original hearing. I forget what date it was. Leslie Honig was there. 3 days prior to that hearing, she had entered a suggestion of bankruptcy into that case file and was there on the court date to inform the court that Ted Visner and Kathy Smith were in bankruptcy. There was an automatic stay of bankruptcy on the lower court proceedings, and Judge Rush proceeded anyways because we weren't there, found us in default, and issued an order of possession to Shelly Sweet. Now, that order of possession is not an order of eviction. It's part one. Part two never happened. Now, we objected to that default order like we should have. And there was a hearing set for September 28th.
Right.
It was our hearing, Kathy Smith and Ted Visner's hearing. Shelly Sweet and Bruce Havens got that hearing canceled, which kept us from entering in any information on our own behalf. And then they administratively closed the summary proceedings to evict us on the 29th.
Right. That's pretty consistent with what you wrote in your motion.
Okay. Is there anything about that that isn't clear?
No, I think that's pretty clear. But, so you've got to the point where nothing occurred at the Isabella County District Court to evict you, and now we pick it up here with docket number 21.
Nothing was done to evict us. I think we're missing something here.
Okay.
Nothing. You just said nothing was done to evict us, and that is totally opposite. Bruce Havens filed this document on September 20th. It was used the following Saturday.
Well, actually, I think I said
Monday,
I didn't
actually.
say this. I meant to say it this way. Nothing was done in the Isabella County District Court to evict you.
Correct.
Okay, so we're clear on that part.
Well, they did issue the order of possession, which made everything confusing.
Right.
Judge Rush issued an order, and then we were not allowed to proceed in the same proceedings. Okay, we couldn't have that order of possession set aside because somebody closed our hearing. And it wasn't us.
Okay.
You know when you know, right? When I petition the court for a hearing, the opposing party can't cancel it. Right?
That's true.
That's true.
Not without your consent.
Correct.
Right.
Well, it was canceled without our notice, without our consent, and then the summary proceedings against us were entirely canceled administratively on the 29th.
Right.
So apparently, either Bruce Havens or Shelly Sweet being an employee of the county, called the court and had them cancel our hearing. We needed to put information on the record on September 28th, and we were disallowed to do that because we went to our scheduled hearing only to find out that it had been canceled completely stricken from the schedule forever.
Okay. So
that order of possession stood without any further activity in the county court with regard to these summary proceedings.
But if the matter is closed in the Isabella County District Court, there can't be any subsequent orders ordering the eviction through the...
Sheriff Leo Matuszewski told the press, the Morning Sun, the Michigan State Police, probably the FBI, that we were just pissed because we got evicted. Okay, Sheriff Leo Matuszewski used that order of possession as an eviction order when he reported what happened to my family.
And this was shortly after, in 2010, then I take it, sir?
Shortly after, yeah. I never dreamed in my wildest imagination that I couldn't go to the sheriff's department and say, hey, look, we just lost our home and everything in it, and one of your employees was involved. I had that conversation with John Tellis, and his response was, sue me.
I'm sorry, who is Mr. Tellis?
John Tellis is the undersheriff, was the undersheriff in 2010 when this happened.
Right. Okay.
When the deputy came, all garbed up, co-worker of Shelly Sweet to our property on Monday, September 27, 2010.
I'm sorry, say that date again. A little slower.
September 27th,
okay.
2010. Mm-hmm. When we were trying to get into our house that we hadn't been evicted from, Shelly Sweet's co-worker, Clinton Steinert, used this paperwork to keep us out, as if it were a summary proceedings at the local county court.
So, I want to understand what you just said. The deputy sheriff used a pleading number 21 filed with this court to authorize an eviction of your property, your house.
Isabella County Sheriff Deputy Clinton Steinert told us we'd be leaving the property that day one way or the other, either by arrest or voluntarily. Right. So I went to see Under Sheriff Tellis. I said, this is just a stupid mistake. I'll go fix it. No big deal. Mm-hmm. And Kathy Smith and I at the time owned several properties. We actually had properties rented. We were familiar with, even though we actually didn't have to carry out an eviction, we knew how the process worked. Right. And Steinert laughed at that. Now, when the notice of intent to sell, take possession was used by Shelly Sweet with Clinton Steinert as an eviction order
See, you said that a couple times, and that's what you believe happened, is they took that notice,
No, I know that's what they did.
Okay,
Because I was there.
So
They used that document, the notice of intent to sell, number 21,
right?
as if it were a court-ordered eviction.
Yeah, like an order directing the...
Yeah, well, the title says, notice of intent to sell and take possession. Okay, the whole title isn't there.
Right. I'm getting back to it, sir. Give me a minute.
Take possession pursuant to blah, 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 blah. To a cop, that means nothing. They just ordered to take possession. This is a notice of intent to sell and take possession. Mm-hmm. Now, if you read through this, it talks about everything we own. Okay, now if you also read through it, remembering that this was filed on September 20th, right. The intent, the criminal intent, was to take our home and its contents the following weekend. We weren't even given the proper time to object to this notice before its intent was to be carried out. Clinton Steinert looked at this document and says, looks legit to me. Clinton Steinert being co-worker of Shelly Sweet, whom we didn't know for over a year. But we immediately on that day saw the collaboration between the two to effectuate this federally court-filed document as though it were a legitimate eviction.
I see. Okay, so that's...
So,
okay,
I think we filed an objection to this on Friday.
Let me go back to that for a second, sir.
Which would have been the 24th?
This one? Does that look right?
When was that filed?
It's easy for me. Filed September 29.
29th.
See what I'm looking at, sir?
Yes, I do. I thought we filed that on Friday, but I was mistaken, according to that document.
Let's make sure we got a good record here. Here's number 21, 22, 23, 24, 25, which has nothing to do, well, 22 is a certificate, but the other three are not related to this property whatsoever. And then on the 29th, we've got the objection is filed on your behalf by Ms. Honig. So it looks, from our docket standpoint, that's exactly what we have. See what I'm seeing, sir?
Oh, I don't know that I'm familiar with number 25 there. This court ordered a motion for relief from stay?
Yeah, let me tell you, I'm going to back up. C23, which is a motion for relief from stay. I think this is filed by Chemical Bank. You want to click on 25 just for a second, sir? Or not?
You think that is an order granting a motion for...
Well, let's just click on it rather than me guess.
Okay.
This is Chemical Bank. This is some property apparently you had in Grand Rapids.
Yeah, that's irrelevant.
Pardon me?
That's not relevant.
Okay, so it's 1432 Kalamazoo. We don't need to worry about that, is what you're telling me.
Well, it ultimately is part of the issue, but for right now, what happened here, it created a cascade failure. We had a property at 1647 Franklin in East Grand Rapids that was financed through a hard money lender named Pinnacle something, a bank/lender. And it started foreclosure proceedings in prior to April 2010, the same year. And I don't know how familiar this court is with the abandonment rules of the state of Michigan, the abandonment laws. 1346 Alpha comes to mind. I don't know why, but I think that's part of the abandonment laws here in Michigan.
You mean if there's a foreclosure?
Yes.
Okay.
In Michigan, the banks can declare or assume a property abandoned unless otherwise rebutted by the owners.
Right.
And that's what happened to this other property in Grand Rapids at 1647 Franklin. We had a buyer. We moved a buyer in on April 1st. The lender came and posted with their attorney, posted a notice of abandonment on April 1st.
What year, sir?
2010.
Before the bankruptcy was filed.
Correct.
Okay. I'm with you. I just want to get that in terms of...
I'm trying to explain and give the court an idea of how screwed up we were in 2010, financially and otherwise. Emotionally, these things are just going on.
Sir, if it's any consolation, that's very typical for people who file for bankruptcy for relief. So don't feel like you're the only person who's ever come here feeling that way.
No, I've come to know a great many other people who are getting it in the shorts.
But
So in the Michigan laws with regard to abandonment state that the I keep forgetting how to use the mortgagee and mortgagor for one reason or another. Anyways, the bank's assumption that the property was abandoned was in error. We just finished fixing the place up. We're putting all our money into getting everything tied up for the new buyer. We moved the buyer in so that his daughter could attend the East Grand Rapids schools, and we were waiting for his loan to close when the bank came and posted a notice of abandonment on April 1st. Now, the laws of the state of Michigan give the mortgagee, the owner, the borrower, I'll just say borrower,
right, that's easy to remember.
15 days to rebut that assumption.
Right.
Okay, which would have been through April 16th, 2010. The bank came in on April 15th, 2010 with an already recorded deed and took the property and kicked out our buyer. Simple case. Super, super simple case. We called the police. The police were there. The police looked at the deed and said, well, shit, man, we can't do anything about this.
Or words to that effect.
Words to that effect. Yeah, that wasn't a direct quote,
Right.
but it was probably pretty close. You know, and I understood that. I understood that the police were looking at a freshly recorded deed. The ink wasn't even dry yet, and said, there's really nothing we can do. I said, that's all right, fellas, just, make a report, and a report was made. So I had a bank come in and take a property from my wife and I, using the abandonment laws of Michigan, violating the abandonment laws of Michigan. And so that was going on at the same time, too. And this happened in April. My home was broken into at 7287 West Fremont in May. So we had that going on. We're trying to help the police find the criminals that came into my house at 7287 West Fremont in Blanchard, Michigan, and completely trashed the place. And the idiots rode there on pedal bikes, and the roads around my house are all gravel, and they rode pedal bikes in the freshly graded gravel. So we're able to follow the bicycle tracks right to their lair. So anyways, there was an arrest and conviction there. And that was 2010. And then in September 2010, Shelly Sweet hired Bruce Havens to circumvent this court's federal bankruptcy stay on the eviction proceedings and create a document to be used as an eviction document in September. And then I spent a couple of months in Florida caring to my mom, who had 2 terminal illnesses that died in November. So
I'm sorry, she passed when?
She passed away in November.
Oh, I'm sorry to hear that, sir. I did not know. So when did you leave Michigan and go to Florida to attend to your mother?
I was down there a couple times.
Do you recall when?
Well, it was prior to her death. In fact, I was returning in November, or at some point prior to Thanksgiving. I actually moved my family out of Michigan after the events of what happened here. The events that happened.
You're talking about
the sheriff's department telling me to sue them. Me telling the sheriff's department that their deputies were involved with looting my house and not being offered any means of redress by the sheriff, and having a complaint or seeking redress against the sheriff's department is scary business. I mean, who's going to take a complaint against the sheriff's department? The Michigan State Police said I was lying and I was crazy and threatened to arrest me when I tried to, and I don't remember the date. I think it was almost a year after the incident, but threatened to arrest me as a trespasser in the police post lobby. And this was a detective sergeant. I think he was a detective sergeant at the time. He said my complaint was so outrageous that I had to be making it up. And if I was still in the police post, by the time I don't know if you're familiar with the police post in Mount Pleasant.
I got to say I'm not. You've got the advantage of me on that front, sir.
He said if I was still in the lobby by the time he came around to the front side of the counter, then I would be arrested for trespass. I left there so shaken up. But this is the same and similar mindset that I've been in for the last, since this happened. I wasn't so worried about the thing in East Grand Rapids. I felt confident that I could handle this. And the way that case was won was the attorney for the bank threatened criminal charges against my wife if she didn't sign off, and threatened to take her kids. And that's how come we didn't get any redress in that case.
I see.
So getting back to the story, I was scared shitless, for lack of a better word. I moved my family completely out of the state of Michigan so that I could handle this and think, or at least know they'd be safe. I moved them back to Bremerton, Washington area in Washington State. You can't really get much farther away than that unless it's Hawaii or Alaska. So we'd been there before. She had friends, she had family, and she had a job opportunity there. And I stayed here and tried to get redress of these grievances. And does that answer your question?
It does. So this is how I'd like to proceed. You have filed this paper. I'm scrolling down, so give me a second, sir. You filed this paper
January 28th.
No, I'm going to go up to this one. The one on November 3rd, 2015. You filed that. And in response, the court gave you some of the action or relief that you wanted. I reopened the case and I waived the fee to reopen it. But here's the concern that I had when I read your motion. I wasn't exactly sure what you wanted me to do, nor was I sure who you wanted to have come in the court to explain to me what they did so that we'd have ourselves a valid hearing. Because it's not good just to have you talk and not hear the other side, just like it wouldn't be any good just to have the other side talk and not have you have a chance to hear what they have to say and respond to it. So what I wanted to do back in November, and you convinced me that we ought to do now, is that this motion, number 113, I should say, needs to be given to whoever you think you have a claim against, and they need to have a chance to respond to it.
Well, I think this court needs to assign a special prosecutor. And I think this court needs to recognize that there's 2 federal agents, at least, sitting in the gallery here that can take this as a criminal complaint and go and along with the probable cause and go make some arrests. I'm talking about fraud on this court. Mm-hmm. I'm talking about the theft of our home and our property through the fraud perfected in this court. Mm-hmm. What's going on, fellas?
Well, sir, I don't have the authority to assign a prosecutor. The best I could do is ask the U.S. Attorney's Office to investigate.
I already did that. They're not interested.
Okay. Well, so keep in mind, I can't do certain things just because I don't have the authority to do it. You want me to send a letter to the U.S. Attorney in Detroit and have her take a look at this matter or not?
Well, I would think that would kind of come naturally since this fraud was perpetrated through your court.
So is that what you want me to do?
I don't know. I don't have a book in front of me or anywhere, for that matter, that explains to me what your capacities are.
Sure. That's
And what I do know is I did go see the U.S. Attorney's Office.
Okay.
I did see the FBI in Grand Rapids.
Mm-hmm.
You know, I have talked to these guys.
Mm-hmm.
But these are issues for the federal court, in the federal court, about the federal court. So if the federal court actually was working to perfect these crimes on purpose, I can understand where I might just hit a brick wall here.
Okay.
And it's kind of what it's feeling like. I'm not saying that that's the case, but you're asking me if I want you to write a letter to somebody else that is talking about fraud on the federal court.
Well, let me rephrase the question. Would you be opposed to having me write that letter?
No, in fact, I would think that you would have done it just by reading the last two documents I filed.
Well, sir, that's why I wanted to bring you in here and find out what's going on. That's why I'm glad you're here. But I need to tell you, I just can't pluck someone from some agency and say, I want you to investigate this. I don't have that authority, so that you know what I can and can't do, okay?
So you're saying that this federal court cannot order a federal investigation?
All I can do is say to the U.S. Attorney, we've got these facts, and I want you to take a look at it.
Everybody's got these facts right straight up to D.C., and nobody's lifting a finger to do anything. So there's complicity.
Well, I don't know if I would say that, sir, because the next thing that we do, regardless of what happens at the U.S. Attorney's level, is that I want to hear from you, and I want to hear from all the parties that you've described to me. Well, you don't need to. To see the evidence is right here. See, this isn't hearsay. Okay, there's a document filed in your court that was used to match and replicate what they couldn't get in the county court that looked like an eviction to secure the property, not only the real estate, but the personal property of my family. Well, those crimes were perfected here. Sir, there's evidence clearly of a notice of intent at number 21. That's criminal intent. That's the filing of criminal intent that these guys need to know to pursue a crime. Was their intent? Well, it's right there. There isn't time enough for us to even respond to this or object to this filing that meant nothing to this court, meant nothing to me, meant nothing to Kathy, meant nothing to the guy that filed it. Its sole intent was to be used to mimic a county court eviction order, and that's exactly how it was used. It was filed on the 20th, and everything in here was executed on the weekend prior to Monday, September 27th. What you know this? How many days did we have to object to a bullshit filing by Bruce Havens? Was it 7 days? Well, let me ask you a question first. When did you say that they moved you out of the property? On the weekend prior to Monday, September 27th. Shelly Sweet, allegedly. Okay, now we're going to step off into the allegations that need to be part of some investigation. Right. Okay, but everything up till now is clearly evidence right here in this court file. Mm-hmm. Okay, allegedly, Shelly Sweet invited her friends and coworkers from the Isabella County Sheriff's Department into my family's home to take what they wanted. Okay, they cleaned us out. They cleaned out the whole place. I think it started Saturday, according to the neighbors who are now having a lot of medical issues, and proceeded all the way through Monday, September 27th. I saw Robert Wheeler and Shelly Sweet loading Robert Wheeler's truck on Monday, September 27th, and Deputy Steiner was there, and he refused to look in the back of this truck. It had a canopy on it and tinted windows, but even with tinted windows, you could see the light through the other side, and it was mounted with stuff. Now, Shelly Sweet and Robert Wheeler said, well, yeah, we know this isn't an eviction, but we have one at home. A real one from the county, signed by a judge, or signed by
they didn't say it was from the county, but they said they had a real eviction order to get us out. We were at the property 3 times with Steiner that day. And this was like the second time. Shelly Sweet says, well, you're right, this is an eviction order, but we have one signed by a judge. We just need to go get it. So, Shelly Sweet's coworker, Deputy Steiner, told Robert Wheeler he could go home with the truck full of stolen property and get a court-ordered eviction that didn't exist. Okay, Robert Wheeler left. Robert Wheeler came back driving a car, not driving the truck and trailer that was full of stolen property, and no court order from anybody signed by any judge. And it was at that time we finally got our house back empty. My wife and I were given the key reluctantly, but the way Deputy Steiner arranged this whole transfer of possession, not only were Shelly Sweet and Robert Wheeler issued off the property before we got the key, Steiner himself was in the car and off the property before we gained entry to our house. And before his taillights were out of sight, I called 911 to report the burglary of the contents of our house. Steiner came back later that night and abducted me, threw me in jail. I thought for sure he was taking me down some 2-track somewhere to put a freaking bullet in my head. I was so freaked out. You know, we'd called the police several times that day, and there was a breaking and entering, and it turns out all of our property was stolen. And this alleged cop is telling me I'm a trespasser on my own property, and then he tells 911 dispatch, and this is all in deposition. I'm sure these FBI fellows are fully aware of Steiner's deposition under oath, that support all of this. Everything I'm saying. I mean, I understand what you're saying. What I'm saying is that there's a fraud here, and it's prima facie. This court was used to facilitate crimes against my family. And it did. Now, you know, it could be quite a cute racket, I guess, if all lawyers knew about this little notice of intent to circumvent the automatic stay of bankruptcy in all the lower courts. I think that might even be a valid source of investigation too. You know, how many automatic stays of bankruptcy with regard to real estate are being circumvented by the erroneous bullshit filing like this that says, hey, we're going to commit a crime and we're going to do it on such and such a day. You know, because he wrote that there doesn't make it lawful, doesn't even make it legal.
Sir, for me, where the story's not complete, and I'm not saying you're right or wrong, I'm just saying it's not complete, is I see this pleading, number 21. And I read it.
Okay.
But I don't have the...
Well, we forgot to answer.
Pardon me? I'm sorry.
I don't know what the federal courts of civil procedure are with regard to bankruptcy law and filing an objection to something else. I mean, what's the? Can you please tell me what this court recognized as the time requirement for filing an objection to anything else filed? Now, this isn't legal advice. This is just a court.
Typically, the court would look for at least a 14-day notice with 3 more days afterwards, sir. And the reason I say 3 more days is because the rules of civil procedure add 3 more days to any particular notice.
Okay, thank you.
So,
and now I'd like this court to recognize that this notice of intent to sell, take possession was filed on Monday, September 20th. Its intended criminal actions were carried out the following weekend, which would have been the 25th, 26th, and then Monday the 27th. So in violation of this 14-day notice, I thought it might have been 7. We did file an objection to this bullshit filing by Havens on, we just looked it up. It was Monday, September 28th.
No, 29th.
29th.
Yeah,
29th.
Right here.
Okay. So was that within the 14-day window?
The answer is yes.
The answer is yes. Okay, so on October 6, 2010, we had an objection hearing to a bullshit filing by Havens that was an intentional fraud upon this court to discuss the fact that we had no reason to even stay in this house anymore, because this order was not only just used as an eviction when it clearly is not. It has no legal standing whatsoever, this notice of objection, all the way up until October 6th, which is beyond the date everything happened. So to apply any counterweight to this document that was only first addressed in an objection hearing on October 6th, it having any force or effect or legality at all prior to October 6th is just ludicrous. It's insane. I lost my train of thought.
You lost your train of thought, you said?
Yeah.
Oh, I'm sorry.
I was going somewhere with that.
Okay. And where I'm going with is that I want to hear, I've heard from you, I want to hear what everybody else has to say, because
It's right here.
What's here, sir, are a number of pleadings. I don't really know what happened during those days.
Okay, well, prior to the 14-day plus 3, I will just say 14, but we're inside that window to object to an erroneous filing by a bar lawyer.
Yeah, Mr. Visner, what happened was, and you're outlining it perfectly in terms of the notice of intent was filed. Your attorney, Ms. Honig, filed a response to it 9 days later, well within the 14 days. The hearing was set, you'll see here, and we set it, and then there was a request to move it up, and we moved it up. And then there was an agreement.
At that motion hearing on October 6th,
Okay.
you called Bruce Haven's notice of intent to sell, take possession, a motion. It's in the audio transcript. It's been on YouTube for a couple of years, 3 years now. Now, this was an objection hearing scheduled by Kathy and I, and through Leslie Honig. It was moved up by Bruce Havens, Shelly Sweet, by our consent. And we wanted it heard quicker too.
Right.
In fact, we'd have come in the same day, but it wasn't an option. So at this objection hearing, you called it a motion. You called Bruce Havens erroneous filing a motion. Bruce Havens thanked you for calling it a motion, knowing it wasn't. It's in the audio transcript.
Okay.
So, I mean, thinking about this as if, I might be a judge or something, and looking at the filing of the notice of intent to sell, it probably should have been presented as a motion.
Mm-hmm.
So, that's how I'm kind of thinking that. Well, you didn't know. You do this stuff every day, day in, day out, and they all probably kind of run together at some point. And you're sitting there looking at this document, so it's erroneous, but you assume it's a motion. But this wasn't supposed to be a motion hearing, and it wasn't a motion hearing. And if creditors have to pay for a motion, I'm quite sure that nobody will be able to show that anything was paid for this erroneous filing as if it were a motion. But the point still remains is that the objection hearing on October 6th was intended to address things that happened prior to, and converting it to a motion, calling it a motion, making it a motion when it clearly was not a motion, did help muddy the water, because we were there to object to this erroneous bullshit filing by Bruce Havens and Shelly Sweet. Mm-hmm. And now it's being discussed on October 6th as a creditor's motion, more so than a debtor's motion. I think it's real important that this court re-listen to those audio transcripts.
Which ones do you want me to listen to?
Well, the October 6th hearing that resulted in the order on the 8th.
Well, sir, I'll do that in due course. What we need to do today, I think, is
this is prima facie evidence and proof that crimes were committed. Okay. The lawyer Bruce Havens, being a lawyer, knowing way more than I did in 2010, used this court to create a document that resembled a win for his client in that it resembled an eviction. I mean, to a police officer, notice of intent to sell and take possession. And it's signed. Okay. Well, it didn't matter that Bruce Havens wasn't a judge. The paperwork by the cop, who's a sheriff's deputy that issues, warrants and stuff, they're all signed, supposed to be signed by a judge. And it's supposed to say judge and blah, blah, blah.
Right.
But he accepted it. And it took us all day to get our property back. During the same day, more content from our home was stolen by Robert Wheeler and Shelly Sweet because Shelly Sweet's coworker, Clinton Steiner, used that document as if it were a lawful, legitimate court order.
Number 21.
In number 21. And on the property, I told Clinton Steiner, I said, that signature, that electronic signature, is not a judge's signature. That's right. Shelly Sweet's lawyer.
Right.
So from the very first interaction with police, he knew that he was dealing with a document that basically meant nothing. I mean, pleadings are signed by those who submit them, but this one was created to look like it was signed by a Daniel S. Opperman.
Well, clearly,
or equivalent.
Clearly, I didn't sign it.
Clearly, no. But it was, if you look at your signature block on the October 8th order and you look at the signature block on the filing itself,
right,
the notice of intent to take possession, unless you knew the parties involved personally, you don't know.
Well, I don't know. The order that really, I think, brings us here, number 35, identifies who I am in my position. Sir, I'm not saying that what you tell me is wrong. I'm just saying...
I didn't say it looked identical to yours. I said it looks a lot more like a federal court judge's.
Right.
Because he had taken out specifically on a second filed document the attorney for Shelly Sweet.
Yeah, I see that. And that's why I want to hear from everybody. I don't know how you look at this order, number 30.
What is the defense to that?
Pardon?
Just out of curiosity.
Pardon?
You want to hear his side? I mean, what are you going to say? Why did you take your name out? Oh, it was just an accident. Or my templates are different, blah, blah, blah. I mean...
No, but sir, what I'm really interested in knowing is, if you look at number 35, and let's say, because it is, that's basically the form that we use when we sign orders. I mean, obviously the date changes every day of the week.
Right,
you
right.
get that. But this part is always about the same. Because that's how we sign our orders and they become effective, electronically. And I really would like to hear someone explain to me how you take number 21. And I understand exactly what you told me, sir, because I note the differences in what was 20 and 21. But, I see, I'm looking at the second page of 2, document number 21. That doesn't look anything like a court order to me. And I'm not going to ask you, does it to you, because it's not an unfair question to you. I want to know, who acted upon this thinking it was a court order.
Isabella County.
Pardon me?
Isabella County.
I know, and that's why I want to have them in here to explain to me how they were confused by that.
Well, I think, I don't know, our entire case against the county should be entered into this case for evidence. And I think you could call for that. I'm pissed poor. I don't have any money. I can't get that case file here.
What?
I sued Isabella County.
Okay.
Okay.
Where'd you do that?
In Isabella County.
Okay.
Duh. Back then I didn't know anything. In that court case, our testimony, Shelly Sweet answered our original complaint like a confession. Okay, at her deposition, she said, yeah, we took all this stuff. We gave it to, my friends and coworkers. These are in the depositions. Okay, even in this court, the transcript that I asked this court to listen to again, Shelly Sweet says, yeah, we just, took what we want, threw away the rest, and gave it to our friends, whatever. Okay, there's another case in Isabella County, personal protection order against Robert Wheeler, where I sought a personal protection order against him, knowing him and Shelly Sweet had just stolen all our property. With the help of the sheriff's department, I filed for personal protection order, and that was actually heard by Paul Chamberlain, the chief judge in Isabella County. And Chamberlain, in his order and opinion, he never granted my PPO, but he went off on Wheeler for a good while. And when I went to get a copy of those records, they'd been changed. Paul Chamberlain's assessment prior to the close of that PPO was significantly shortened because he laid it on really thick. And at this time, when we filed for a personal protection order against Robert Wheeler, this was prior to initiating the civil suit against the county, and the chief judge, Paul Chamberlain, did not realize that Robert Wheeler was associated with Shelly Sweet as a boyfriend, and that Shelly Sweet was, in fact, employee of the Isabella County Sheriff's Department. This is all relevant data, but this is not as relevant with regard to the prima facie evidence that I'm asking this court to see right here. Now, unless this court can explain and define how this notice of intent to sell is used every day without any interaction from the court from the time it's filed and the time its criminal intent is carried out, this court has no option but to act on this, in my opinion. Mm-hmm. It's filed on Monday, September 20th. The criminal intent was carried out the following weekend. We did not have the required time to object to this bullshit filing. And by the 27th, nearly everything in our house had already been stolen. It was basically vacant. And we really had no reason to stay there. We had several other properties we could go to. This court knows that. They're all listed in our bankruptcy. So we retreated to 7287 West Fremont, not because we wanted to give up this house, but because Shelly Sweet, Robert Wheeler, and the Isabella County Sheriff's Department said what they were doing was cool. Even though they couldn't prove we'd been evicted, we'd finally been able to explain that this filing was just bunk. And we were finally given our key back. And after making entry, discovered all the rest of our stuff was gone.
Okay.
Called 911. Steiner came back and abducted me. Took me to jail. And I thought he was going to shoot me. I mean, the events of the day were so freaking bizarre. I didn't think I was going to get to jail. I made a video about this, the ride in, he's laughing. And he goes past the jail to a gas station to get gas. Because I'm his prisoner and he's making an example of me in the back of this squad car sitting on mission when we just drove past the sheriff's department where he ultimately took me. He was making an example of me. He was damn happy to be doing that. And it's self-evident. It's self-evident in the dash cam. It's self-evident by the tour we took to take me for some violation they had to make up a number for. Misuse of the 911 system. It's misuse to call 911 when a series of events initiated by this document happens to my family. My kids still ask me, Dad, why did the police take our house and all my stuff? You don't know what that feels like. You can't imagine. The police, the authority that they're supposed to look up to, the authority that I've looked up to my whole life. Suddenly, I have to look at my son and say, there's no good reason. What do you do?
Sir, we need to let you have the opportunity to tell me this in a form that's appropriate. It'd be here. So you're
Huh?
right. It'd be here in this place. But I want to have everybody here so that you can ask them questions and I hear everything. In order to get that going, I need to have you take your amended motion that you filed and send it to those people that you believe owe you money. And those would be at least the 5 or 6 entities and individuals we talked about earlier.
You're talking about the November amended motion? You want me to amend it again?
No.
Oh, you want me to send it?
You don't need to amend it unless you want to, sir.
You need me to send it to Havens and Sweet at her last known address. How would this court like me to address all of the return mail I've gotten?
Forget about that in terms of don't worry about sending anything back to them. I just want you to send that that motion, the amended motion, and I think you had it right. It's 113. To whoever you think you have a claim against such that they would owe you money. You know what I'm trying to say?
Well, I've gotten a lot of advice from a lot of different people in the legal profession. Most of them don't even want to have anything to do with me because of the size of the beast I'm battling against.
Mm-hmm.
But one of the things that they all say is, or most of them say, is that this should probably be handled in a stair-step process.
Okay.
Which to me is...
I'm not sure I understand what you're saying. Go ahead and keep on going.
For sake of argument, this issue should first address the actions taken by Bruce Havens and Shelly Sweet and Robert Wheeler.
Okay.
Recognizing that Sweet is an individual,
mm-hmm.
as a flesh and blood human, worked for the Isabella County Sheriff's Department.
Mm-hmm.
I'm not sure. You know, I've had so much advice so many different ways. It's all kind of blurry, but the prima facie aspects of what I'm talking about right here only include Shelly Sweet, Robert Wheeler, and Bruce K. Havens.
And those would be the 3 individuals you should give that to. Along with, you and I talked about it earlier, how much notice is required. There's a form, I think it's going to be available across the hall at the clerk's office, saying that they've got 14 days to respond.
14 or 21?
I would like to have on this one 14 days. Because I think faster is better than slower, don't you?
We're at the 6-year mark, Your Honor, so hell yeah.
Okay.
What can this court do in the form of injunctive relief right now?
Right now, what kind of injunctive relief are you looking for?
I would like these members in the audience to stop pursuing me like I'm a damn terrorist because I'm seeking redress against government.
Mm-hmm.
That would be a really nice start. The Michigan State Police, the County of Isabella, I mean, it just stands to make sense. I'm seeking redress, so they're outlining me as a terrorist. I've been under criminal investigation since 2011. I think it was right after I filed the complaint in the county court.
Mm-hmm.
I don't like the feeling. I look out my driveway every 15 minutes to see if I'm going to get raided by black SUVs. It's hell. It's truly hell.
I don't have the authority to do that, sir.
You don't have the authority to issue an injunction.
I can't stop properly authorized.
You can't stop retaliation.
I really can't, no.
You can't stop retaliation. You know, this harkens back to John Inhalsen, the lawyer for Foster Swift, who threatened my wife with criminal charges if she didn't sign affidavits releasing the bandits that stole our Grand Rapids house with over $120,000 worth of equity in that we had just sold. And we were waiting for our buyer's loan to close. It sounds like, to me, the very same scenario. A little different scale, maybe. But what this court is saying is that the FBI and the sheriff's office and the state police can collaboratively work continuously to make me look like a terrorist and keep me under constant investigation. Admittedly, the criminal investigations into me started in 2011. That's 5 years ago. This is how I'm supposed to live. This is my pursuit of happiness. 5 years? For God's sake, you don't got nothing yet? Leave me the hell alone. You can't do anything about
Can't stop local authorities or
the persecution
from investigating. I really can't.
This court should recognize that the same unethical practices that lawyers are prohibited from doing in the professional rules of conduct, threatening people with criminal legal issues, and taking their children based on those criminal pursuits, is unethical in this situation. And I will do something about it. People cannot be persecuted for seeking redress. It's a First Amendment right. It's an inherent right. The right to seek redress is everybody's right given to them by God. Not these guys, not you, not anybody. Seeking redress in the state of Michigan is